Good afternoon. Thank you very much for coming at this late hour of the week. I would like to welcome to a small table ronde, which is dedicated to a kind of launch of the book that I edited it with Ineta Ziemele, the impact of the European Convention on Human Rights and the Democratization of Central and Eastern European states. The book is very important not only because it's the only book which is dedicated to Central and Eastern Europe, but also because it has judicial perspective. It means that we have 20 judges which are contributors. We have also academics which are contributors. So there are kind of dialogues between judges and academics. But the majority of the contributors are judges, so they are judicial experience, and also lawyers from the registry, which are now who are now with us in this room. And I think this is also what gives the unicity of this book. I will now give the floor, because I have played several roles this evening. I will now give the floor to Judge Lopez Guerra, who is the president of the Section 3 and who is going to speak about the European Court of Human Rights and the Central and Eastern Europe.
Thank you, Iulia. Good afternoon, and first of all, well, I must say I'm going to talk more about the book than about the Eastern Europe. But first of all, let me congratulate Iulia and Ineta for the wonderful idea of first organizing this seminar on the Convention in Central and Eastern Europe, and second by the publication of this book as editors. I think that the book first is very interesting because of the information, and there are not too many sources organized and coherent sources of information on the impact of the Convention on Eastern Europe, and really, for this point of view, is very useful. Also, because the approach is very clear. I mean, they say that clarity is the courtesy of philosophers, but also is the courtesy of jurists. And really, this book is, contrary to many books on law, is easy to read and interesting and giving a lot of information. And furthermore, it's a good thing, which is that all the chapters have a very similar structure. I mean, explaining the entrance into the system, the effects of the convention of the system on different branches, and so on. So really, it's also easy to read, and it's relatively easy to get a general idea of the influence of the convention in Central and Eastern Europe. And of course, there is a very, very important point. All the chapters, the substantive chapters on each one of the countries have been written by specialists and citizens of this country. Most of them judges of this court. And of course, they have a first-hand information, and they give a very good impression, idea of what is going on in the different countries with respect to the convention. But I must make a precision. It is true, I say, with two exceptions. There are two nuns instead of Central Europeans who write in the book, which are the former President Wilhaber and Spielmann, which make the introduction. It's not people coming from a different area, not particularly specialists on the thing. And I must say that this position is also my position in this roundtable with Iulia Ineta and when he comes. So that I feel in good company, not only here, but also with Wilhaber and Spielmann. I share somehow the approach both of them follow in the introductions, which is, I think, in two points. The first point was the importance for the convention system of the entrance of Central and European countries. I mean, the reverse or opposite way, not the influence of the convention of the countries, but the influence of the Eastern European countries in the convention. And then, in this same way, the change in the convention system derived from this enlargement to the Central European countries. And I think that this approach is really interesting. I must say there was sometimes inspired also by the final words of Ineta in the book. We also was kind of cannibalizing or plagiarizing what she said, but the idea is interesting. I mean, what was the reverse incidence of this in the convention? I think there is a curious, I mean, when you look at history, it is clear, or at least many of the commentaries consider that the creation of the convention system in 1950 was a result of the context of the situation of confrontation between East and West. I mean, with the democratic constitutional systems of the West and the totalitarian is maybe one of the central questions, not only in the European system but also in other, for instance, in the American system. And I think it is stated in many of these chapters, which is the internal position of the convention law in the internal legal order, the order of sources of law, the problem which is called sometimes the problem of conventionality, not of constitutionality but of conventionality. What happens when the internal legal norms enter somehow in contradiction with the conventional norms, with the case law of the court, or with the mandates of the convention. And then it is very interesting how each one of these chapters treats this aspect, because of course practically all of the constitutions of the Central European countries proclaim the superior position of international law during the convention over internal law, well, with the exception of course of the constitution, but in general you can say that being monist or dualist system, all of the constitution proclaim that the international law, the convention, must be considered as a level above the internal law. But it's also curious to see that the consequences of this proclamation are very different according to the country, because the main question is if an internal law enters in collision with the convention, and the convention is supposed to be the superior law, then you have to apply the convention and not the internal law. But who decided that? And this is the main point, because there are two alternatives. A judge sees the internal law, sees the convention, says the convention is contrary to the internal law, and then he decided, in the particular case, decided to apply the convention and not to apply it. I mean, direct application of the convention. Of course, it gives an enormous role, an enormous power to the ordinary judge who has to decide. But there is another possibility. I say, well, really, if the Constitution says that the convention is superior law in comparison with internal law, then the internal law will go against the mandates of the Constitution, because the internal law will be opposite to the convention. So the result is that we have a problem of constitutionality. The internal law, being opposite to the convention, is opposite to the Constitution, then we have to solve it. Normally, constitutional problem has to be solved by the constitutional court. So the ordinary judge, instead of deciding and say, well, I have to apply the convention, well, wash his hands and send the case to the constitutional court, which of course make the thing more complicated and so on. Now, I think this is a very, very interesting problem. I see the problem of conventionality, because really the efficacy of a norm depends on its application by the judges in the concrete case. And looking at the different chapters, and I finish with it, you find very different solutions in two countries. For instance, in Hungary and in Latvia, the authors say, well, we are conscious of the problem, but the solution is not clear. It's with these words, well, really, it is not clear whether it must be the ordinary judge or must be the constitutional judge, the one who decides. In other countries, the authors say, no, really, it is the ordinary judge, the normal judge, who has to decide on the primacy of international law or the convention. I think the cases of Macedonia, Russia, Armenia, but they say no, even Estonia, where the Supreme Court is the last one who decides. And then there are a curious situation. There's a curious which is very similar to the one in my country, in Spain, which is the situation of Croatia and Poland, where both solutions are possible. I mean, the ordinary judge may decide, well, I'm going to disapply the internal law, because the convention, but also the judge can say, well, this is a problem of constitutionality, I will send the case to the Constitutional Court. And these possibilities are open. And like in Spain, in Poland, in Croatia, in Spain, the judges normally prefer, as I say, to wash their hand and send the case to the Constitutional Court, which, in my opinion, poses a problem of efficacy. I think that one of the maybe the goals in the future will be to make possible that the application of the convention becomes effective by being a direct norm binding the judges in concrete cases. I think all these reflections come from the reading of this book, and really I am here to recommend it, in that what I'm doing. And frankly, for me, it has been very interesting because the problem posed are not Eastern or Central European problem, but problems concerning the application of the convention, and I would say also the application of international law on human rights. And with that, I finish, and thank you for your attention.
Thank you very much, Luis. So when I intended to introduce this book, I wanted to speak about this book as an intellectual project, as a long-time project, as well as a legal project. Why as an intellectual project? And because this idea of Central and Eastern Europe, I think it was to my mind, and I think to the minds of all the contributors at least since the fall of the Berlin Wall, when we start to construct ourselves in a more mature way. And I think the idea with what happened, what was the communist regime, what was the totalitarian regime, was something that was central to our mind, and also the relation with the human rights. So it is an intellectual project because this project started to be with me. I think I'm not the only one. When I started to study international law, and afterwards when I started to study philosophy, and it is an intellectual project because I don't have an answer as Pierre Manon, one of the French philosophers in the Raymond school, said, maybe the communist totalitarianism is the most enigmatic, still the most enigmatic regime, and it still has to be from the last century. We don't know what was really with this regime. So this intellectual search, I think, it was in a sense with me all the time. I have written, I think, before this book a lot about the topic with different methodology, law, but also political philosophy. And before starting this project with Ineta, I had the pleasure to work with her to another project, another book, the International Doctrine During Real Communism, published with Sorbonne, my colleague Emmanuel Joannet. So I see this in a certain way as a kind of continuation of this intellectual search of totalitarian regime and human rights. Another thing that came into my mind as very important is, I think in a sense, the relationship with Judge Ziemele itself. And when I came here, one book of Richard Rorty, Ironic Contingency, Solidarity came to my mind, book which was published in 1989 and spoke about private irony and liberal hope. I think it's very much the time to speak about liberal hope in our days. But also the book speaks about the Marcel Proust, given the importance of finding certain individuals in our lives. And I think this book also started with some 16 years ago, where I met Ineta Ziemele at the Subcommission of Human Rights, and after when we were elected in the very young at the board of the European Society of International Law. So it was a common project to defend and to impose, in a sense, international law from Central and Eastern Europe, and in a sense to empower, if you want, the lawyers from Central and Eastern Europe. We had done this very much when we worked together at the European Society of International Law and through different intellectual projects. And I think I see this as one of this intellectual project that one is of this project that we have together, and it marked this, common understanding about Eastern Europe and common understanding about Western Europe, Eastern Europe, human rights, and international law. On the legal point of view, when we started this project 4 years ago now, we thought about the reception of the convention in Central and Eastern Europe. As Judge Lopez Guerra rightly said, we had a certain scheme, we had set a certain pattern, how we wanted to measure legally the impact of the convention on a democratic change in Eastern and Central Europe. This can be measured in every country because it's the process of reception by itself in the respective countries. We have to say that the idea of impact, in academic terms, the idea of impact of the convention is an idea which was, and the reception is an idea which was also taken in the book published by Helen Keller and Alex Wheatstone in 2008 about the reception of the convention in comparative in different countries. But we focused on Central and Eastern Europe, and we found the specificity of Central and Eastern Europe. It means that we look to this domestic mechanism, to the legislative level, to the executive level, to the judiciary, also to the relationship with the constitutional court, which is essential. And all this model, I think, it varies from a chapter to another, because some of our colleagues find a very important role, for instance, to the history. We have plenty of chapters about to propose, for instance, the chapter written by our colleague from Czech Republic, Judge Pešar, put a lot of emphasis on history. Others have focused on the relationship with the Constitutional Court. Others, but all of them, they take into account in all these levels. They think how this change occur, which kind of mechanism it worked, and how it was this dialogue finally between the European Convention and the institution. This dialogue, but also the creation of this institution, because what we had discovered, also all of us, it is that the institution were not there in great majority. So by the convention by itself, the institution were created. It's another understanding of subsidiarity that was taken by Ineta in her conclusion. So this is something that's was central. This kind of project and this kind of scheme that we have, and everybody has followed in order to give unity to the book. Why judicial perspective? And I think this is a kind of other, I think, intellectual and academic project. I think judicial perspective are different, even if the majority of the colleagues were, they were professors, so or they are judges or professors, or they are judges and teachers, or they were lecturing, because now this is the dimension of a judge. Here, a very complex dimension. Having a judicial perspective means not only to have something that you are an insider and you know better, and you are in the composition of these cases that are quoted here, but also I think it means that you are writing with a certain restraint. That restraint that you don't find in academics. When you are writing as an academic, you can be effervescent, you can do a lot of style conception. When you are writing as a judge, you think all the time to be more, to be reserved, to be restrained, to have a certain vision, because a certain more limited vision of exposure. And I think this kind of restraint gives the book a certain style, which is unitary, and it's giving this kind of what we call the judicial perspective, insider, deep in the topic, but also with this restraint that I spoke about. So that it is a book which is not written only about judges; it's written about judges and academics, and between judges and lawyers. So we have kind of dialogue into this among these authors. But I think that at the end, this perspective, because it's the first book which is written by so many judges, it's also something which is new, a new perspective, a new kind of methodology, which we have it in this book, and maybe we can repeat it.